Hey, Quentin. Hey. Can you hear me? Unmute my speaker. Oh, hold on. I need to turn up the volume. Where's the volume? Oh. Is that better? Can you hear me? I can't hear you. Oh, you're muted. Okay, hold on. Hey.
Can you hear me now?
Yes, there you go. You can unmute yourself. Hey, Mike, can you unmute yourself? Do you see how to do? Okay, cool. You're unmuted. How are you?
I'm great. How about you?
I'm doing well. Doing well.
Guess what?
What?
I have an 85 average in statistics now.
Hey, I knew you could do it.
I got a bunch more gray hair.
Congratulations.
No sleep.
Hey, Billy Petite's struggling through biology, so he's right there with you. Hey, unmute yourself. Can you figure out how to do it? Yeah.
I think I got it.
Hey, how are you?
Good. How are you guys?
How are William?
Yep.
Excellent. I'm not sure I've ever seen you face to face. I have people come up to me at conferences and say, hey, I'm in your class. And I said, well, you're going to have to help me out here, because I don't know who you are.
That happens to me when I take classes down at Gypstick and recognize names but don't have faces to go with them.
Yeah, it's really hard sometimes. It is hard.
I'm good with faces, but I stink at names.
Well, at least you recognize them, Quentin. That's important.
Well, I'm not sure I recognize these faces. I mean, I think it's the first time seeing these faces.
That's true. That's true. We need to do this more. I keep telling myself every semester we're going to do this more often, and it never. Time gets away. I think Kelvin is not going to be here. He's at Gypstick, I think. I don't know about Heidi. I was hoping that she would come up here. Where's my paper? And so she's on campus here. Who else? Karen. I don't know about Karen and Billy and Veronica. I don't know. I haven't heard from them if they're going to make it or not. So we'll give them a few minutes. That semester's drawing to a close.
Oh, yes.
Oh, yes.
Too bad. So sad.
But somehow I don't think you're sincere. Is everybody signed up for summer?
Yes, ma'am.
William, are you signed up?
No, we have a little one due in August, so I'm.
That's right. That's right.
Yep. So I'm gonna be back next spring.
Okay. Okay. Just keep in touch. Keep in touch. There's somebody else. I can't remember. George. God, what's his last name? In one of the other classes, he had a baby due maybe this semester.
Jetson?
No, I don't think so. I don't think so. What is his name? I can't remember his name. He goes by Butch, I think. But anyway, he may not be going this semester just because he has a baby.
Yeah, seemed like a lot to try to juggle.
Yeah, I'm sure. I'm sure. Is this your first?
Yes, it is.
Oh, how fun. How fun. That'll be great.
Yeah, we're looking forward to it. I'm
sure. I'm sure. That is a fun thing. Jimmy Beck, who has been in several classes, he's the City of Wander. They just had a baby. The first part of the year, I guess, and it was their first, so he was pretty excited about all that. We'll give them a few more minutes and see if they're coming. Let me email real quick. I have nothing from anyone.
So what departments do you guys work for?
Or,
For who?
I'm with Carroll County Fire Rescue.
Okay.
I'm in Columbia County.
Okay.
Yeah.
I'm in Forsyth County.
Okay.
What rank are you guys?
I'm a lieutenant.
District captain.
Volunteer support.
Okay.
Quentin, I talked to your chief the other day.
You did?
I did. I saw him at a conference in Savannah, the Chiefs conference. He was singing your praises.
What did he say about me?
He said you were a good guy. He likes having you around.
And what did you say to him?
I said you were a great student. That I liked having you around too. Hey Heidi, unmute yourself. Can you unmute yourself? Heidi. Heidi chimed in, but she seems to be muted. She must be on her phone. She's probably trying to figure out how to unmute herself. I started the meeting muting everybody, and that probably was a bad plan. I probably should not have. Let's see. All right. Let me go up here. Whoop. I don't want that. I don't want that.
Yeah, she's definitely on her phone. I can see a muted phone symbol.
I figured out how to unmute her. Heidi,
Yes,
are you here?
I'm trying to be.
Okay, you are now, I think. Hey, are you on campus?
I am.
Do you want to come up to my office?
I will.
Okay, that's fine, because we can share. You want?
Okay, I'll be here in a minute.
All right, see you.
We can hear her, but we can't see her.
Yeah, she was just on her phone. She's gonna come up to my office, and that way we can see her too. I'm gonna move around a bit. She stays pretty busy here on campus with our students. All right, I'm gonna move. I'm moving around here. So when Heidi, there we go. All right. All right, so that's just Billy and Billy and Karen, and I don't know if they're joining us tonight. When Heidi gets here, we'll get started. Are y'all enjoying this class?
Oh, yes.
Yeah.
This is actually, as far as relating to the job, probably the best one I've ever so far been in. I've had several incidents where I've used what I learned here and applied it to work. Just in the role I'm in, I've found a lot of useful stuff out of it.
Yeah, it's one of my favorite classes, I think, because it is so relevant. You know, as you progress up in the job, it's less about the firefighting and the technical part of it, and it's more about the people. And this class really speaks to that, all the legal issues and complications that, and especially this chapter for one, but they're all of them. You know, you read a chapter and then you look at the news and you see that the two things are very parallel, especially if you're looking at like public safety or, you know, fire rescue type news. You really do see where there's so much personnel. And the guy that wrote this book, I've actually heard him speak. He's he's a lawyer. He was a fire chief. I think he's retired from the fire chief, but I've actually emailed him on occasion, and he's emailed me back. So he's very genuine. And I even thought about seeing if he'd be willing to do a Zoom class for us one time, and I may do that. So I really like this course. So we're doing personnel management next semester, I think. And so it kind of ties it all together, certainly, as well. So
one thing it did for me is the book, actually, it's very modern and up to date, and it dispels a ton of rumors you hear about fire service law and things that I was fascinated by the sovereign immunity chapter. That, how it does break down into, it's just not every government's immune.
Girl.
So.
What I found kind of interesting about it is there, at least in my department, unfortunately, we have a lot of kind of turmoil. We've got he's not new. He's been with the department for like 20 years, but he's new to our operations chief. And he's kind of created a kind of almost an adversarial relationship between the administration and the field. So obviously, like you were saying a second ago, there's a lot of, what people are trying to decide what would be considered hostile work environment, what's just, and unfortunately, one of our stations is really, this chief is always, basically sneaking into their station when they're out on calls and leaving before they get back. Just a lot of underhanded type of stuff like that, when they start, murmuring the whole hostile work environment and stuff like that, being able to open that chapter and say, well, what you're describing is probably, what they call a petty oppression, but it hasn't crossed that threshold into, what could be considered a legal issue. So it's, I don't know, it's almost, it feels like it's preparing us and teaching us the rules of the game. So it's not just, the administration knows the rules and they do what they want and there's nobody who can second guess them because nobody else knows how the game is played to know when to throw a flag.
Exactly. And I think what Mike said too, it dispelling a lot of the rumors. There's one chapter that starts out in the book that says, you can't do that, it's against the law. It's like, what law?
Mm-hmm.
And that sort of thing. And so we really do, it really is very relevant. Well, Heidi's here with us. Say hi.
Hello.
There's Quentin, there's Mike Holberton, and do you go by William?
Matt, usually my middle name, but.
Oh, Matt, these middle name people. There's William, because Mike Holberton is a William. So Matt. All right, well, let's get started then. We were going to talk about these cases that were assigned. I hope everybody had a chance to do them, that kind of revolved around Chapter 12 and the discrimination, the implications on discrimination in the fire service. And so, Matt, we'll start with you, if you don't mind, since you are up. Your name was at the top of the list.
All right, that's fine. The case I was given was the Watts versus the city of Norman, which is in Oklahoma. It's the case of the African-American fire captain who got into a verbal altercation with one of his guys that progressed into a physical altercation. And, by the time it was all said and done, that captain, Greg Watts, was punitively demoted back to the rank of firefighter. And rather than accept that demotion, he just went ahead and retired. Where his point of contention was, and I kind of agree with him, is that, he was faced with this demotion after this whole incident, but no disciplinary action was taken against the firefighter who he had the altercation with. So he, understandably said, hey, this doesn't look right, and, filed a Title VII civil rights complaint and, accused them of racial discrimination. What the courts ultimately ended up saying was that his firefighter didn't have the same responsibilities that he did. So in order to claim racial discrimination, he needed to show that there was another person who was what they called similarly situated to himself that was treated differently than him, so that the only remaining explanation could have been race. What ended up happening is they said that since he's a company officer, that he had a higher level of responsibility and they expected more from him and, from a behavior standpoint than they did from his subordinate firefighter. So ultimately, they said that both he and his firefighter weren't similarly situated, and upheld his demotion and didn't really address this other guy not being facing any sort of discipline. So from a legal standpoint, I kind of understand that concept, but I think this is one of those cases where right and legal aren't necessarily coming together. Because, yes, if there's, you ever have a situation where anybody in your workplace decides to hit somebody else, obviously you got to face discipline for that. I don't think being demoted for that was, disproportionate for what the situation was. But the fact that the guy who he had this altercation with didn't face any sort of discipline, I think is definitely a little fishy. Especially from the standpoint that the subordinate was actually the one who started the altercation. He didn't, they said that they didn't have any objective evidence other than him just saying that, other than the captain saying that this guy started the physical altercation. The captain didn't have any sort of injuries or anything like that, whereas the subordinate had a handprint across his face. So, removing the he said, she said, there was actually a tangible bit of evidence, against the captain where there wasn't against the firefighter. But, according to, nobody has any point of contention that the firefighter was insubordinate and refused to come and talk to him and, acted completely unprofessionally. So without question, he did wrong there. So my issue with how it was handled, by the fire department was that the insubordination and, not the battery, but the assault aspect of it, of getting in the captain's face and screaming at him and so forth, how that went unanswered. Because that was never a question. Nobody ever had an issue saying that, hey, that didn't happen. Everybody kind of agreed that that was the case. But how that didn't get addressed, where the captain did, I think was, maybe not legally a problem, but I think from a, what's right, it was a problem.
Okay. And it's another time too where you probably need to look at policies and procedures of the fire department to see, about insubordination and that sort of thing. What's the date on that case?
I want to say it was the altercation took place on Halloween of 1998.
Okay. So it's a little bit older. Okay. Did you find anything when you were looking at that, did he appeal or did he just let it go? How far up did it go?
Honestly, I'm sure I saw it, but I don't think I even made a note of that.
I was looking here. Let's see. He appealed to the United States Court of Appeals, and they affirmed. So I guess he let it go there. So, all right. So they never really addressed that issue. Maybe they did address the issue of discrimination in that. What was the term you used? Suitable.
Similarly situated.
Similarly situated. That's probably the key term that we have to look at. If he had found perhaps a white captain that had been treated differently in a similar kind of situation, then perhaps he would have had a better case about discrimination.
Yeah, and I don't know if, I can't imagine, it doesn't seem like it would be the professional approach, but, the city may have said, this subordinate was in a way subjected to corporal punishment, under the auspices of working for the fire department. So they may have, in that sense, found it inappropriate to further punish a guy who was already, struck. So I don't know. I never saw any evidence to that, but, that was something I kind of considered.
Could that firefighter have taken criminal action, or did he take criminal action against the captain for hitting him?
I don't see any. I didn't see anything about a criminal act having been addressed. To the captain's point, had this been outside of the workplace, if somebody got up in your face and started screaming at you and you reacted, you've definitely got the argument that, this guy invaded my personal space and was making me fear for my safety. and I felt I needed to separate him from myself. Yeah, I think he's got a point there, and it may not be criminal, but it may, well, obviously doesn't fit within the rules of the workplace.
There you go. There you go. All right, very good. Any questions for Matt about his case? Hattie, we're going to go next to you. Tell us about Ricky, or did you have a chance?
I actually remember his. I read his.
Okay. I just have this from another class. Do you want to look at that real quick? Or do you want, why don't we go on to somebody else? We'll go to Mike Holberton. You're up. Tell us about Evans versus City of Evanston.
Would there be a chance that I might have read the wrong case? Because I think me and Matt did the exact same one.
Did you read? Who did you read?
The one Matt just described. I think I saw Williams and I agree absolutely everything he said. The things that stood out to me were if I'm remembering right, it sounded like the captain was being provoked a couple times actually before it came to a head. And then I believe the captain went to this guy, to the firefighter, 2 or 3 try to talk to him about it, and the guy blew up every time. And so it's like there was I think there was some kind of vendetta ahead of time. I think that's the way I read it.
Was the provocation related to discrimination or race or anything like that, or did it say?
No, it was.
It was an argument over the captain bringing his personal laundry to the station and washing it at the station.
Exactly.
Wow. That's really important stuff to be fighting about.
And like I said, it to me sounded like this firefighter had it planned out how this was going to go down, because he kept provoking him. And then the captain a couple times just tried to talk to him normal, and he wouldn't ever talk to him. He'd start yelling at him every time. It's like he knew what buttons to push,
right?
And he pushed the right one. The captain blew up at him, and
that was, I guess, a little works against the captain's favor is that the fire chief said that he had other tools at his disposal to address this argument, this disagreement, before it reached the level of physical violence. They said in my department, I don't have this authority, but apparently in that one, you can send a firefighter home if he's, being insubordinate or things like that. So he had, some disciplinary routes that he could have taken, and they ultimately said that he had a duty to prevent that problem from having reached the level it did. And by failing to do that, he was failing in his position as a company officer. And, that was one of the things that they gigged him on.
Okay.
I did.
I did, because I didn't like this.
Speak up so they can hear you.
Mine was, however you say it.
Yeah, Reese?
It was the, I'm going to talk really random here because my stuff's at home, but it was where they gave the promotion exams and none of the black firefighters passed it. And they were trying to, I may be wrong. Was it them, or they were going to try to take it back and say we're going to do another test, or this is not a good test, but that didn't work. I'm trying to think. I'm cramming.
Was that, I think, was it in New Haven, Connecticut?
It was.
Yeah.
You help me? Did you read mine too?
I believe I did. I mean, I read them all. I
think I did too. That's where I was getting like, hey, I think I did his. But
yeah.
When you start looking at these cases, there's a lot. Throughout my service in the fire service of all those years, promotional exams, testing, and the promotional policies seem to be a great source of contention for these types of situations. And I think a lot of it is the history of the fire service. But where we see a lot of lawsuits or a lot of complaints, is based on promotional testing not being fair or not being equal, or just the whole promotional process not being fair or equal. And that's where we see a lot of, and then they do kind of all run together because, but I think as we go through, what's the date on that one? This was one that was done another month. And I can pull the book in just a second. We can kind of build a timeline. I'm going to get out of the picture.
But the courts actually denied their, or whatever, all these legal terms I should know, but
She should know, she's our local Leo.
they said no, that it was, the test were good, the test results were valid.
This was from a, let's see, this was a very long case too. It was in 2009. So it's like 10 years later after the Watts case. It's very long. The promotional exam was valid, and if I remember right, it was delivered, the promotional exam was delivered by an outside company. Does that sound right?
My department actually uses that.
And basically what the court said is that you can't, the employer could not disregard the results simply because the racial results show a disparate impact. And that's what this piece was about, the disparate impact. So the promotional exam was deemed to be a valid test, even if they didn't like the results. So they ruled in favor of the fire department. Yeah. So okay. So we see that one is about promotional testing. And how many of you use any kind of? Does anybody use outside testing for your promotional exams?
My department actually uses that same company that took place in this case.
Okay.
I've actually sat through one of their promotional processes, and what's actually kind of interesting is they use this case as almost advertising material for their product by saying that, look, it even withstood the court scrutiny that, this is a completely, legally unbiased promotional process.
Well, isn't that interesting? How cool. I was looking for the name of the company somewhere.
Called IO Solutions.
That's it. Industrial Organizational Solutions. Cool.
When I was applying,
go ahead, Quentin. What?
when I was applying for the Atlanta Fire Department, they informed me that since I was a graduate of West Georgia Tech with a fire science degree, that I would be exempt from taking any test to get hired.
Wow.
Really?
Well, that's cool.
Hmm.
And I know a lot of times hiring tests have consisted of like there's an English portion or a reading portion, not English, but reading and a math portion. And so I guess maybe by having a degree, you can exempt people from that. So.
See, we use a third-party test for hiring, but we do not use a third-party test for promotional.
Okay, you do in-house. Have you ever had any objections to that?
Nope.
Or any complaints about it?
Nope.
Okay. Hey, y'all like each other up there in Columbia County.
We try.
All right, so Mike, tell us about your case. Your case was Evans. Do you remember your case, or did you read the wrong case?
Give me a hint.
Okay, hold on. I'm looking. Whoop, there's one in Atlanta, Fitzpatrick. That's not it. I can't find it. I should have looked at the, oops, I'm in the wrong chapter. Maybe that's why. There's Joel Smith. There's United Paramedics. And let's see. This is, oh, it had to do with physical agility testing. 1989. This has failed the physical agility test. Not ringing any bells.
Like I said, I think me and Matt, and I must have saw William and Red studying his, and not.
That's fine. All right, so this is what this is from another class. I will share about Evans because I think this one has really done a lot physical agility testing, 39 women competed for a firefighter position, and it was a class action suit actually, and this goes back to 1985. So and think about one thing I think about when you say it's 1985. That was actually before I was in the fire service. So there was very few women in the fire service. So that's kind of the atmosphere or the tone during this time. There was the physical agility test had 5 stations or events, an aerial ladder climb, a ladder climb, a ladder carry and set, a hose connect, and an agility course where you had to drag a section of hose, climb to the top of a hill, oh, there's a bug, walk through 10 tires, and drag a section of hose again. So let's see. The case revolves around the time cutoffs. The method Evanston used in determining cutoffs was not an accepted way to determine them. Apparently they changed up the time cutoffs from year to year. In 1985, it was 915 seconds. In 1981, it was 890. So they changed up the time for those for passing the test. And so I guess, and that was kind of incomplete, but what the Court of Appeals said, in cases of alleged sex discrimination, the appropriate level of review is the intermediate level. While a practice may be discriminatory, a trial judge has the discretion to fashion an appropriate remedy. The law does not require that the women who failed the test be hired. The judge's decision to restore them to their rightful place on the list of applicants was adequate. So they weren't hired, and but they put them back on the list of applicants, I guess, so that they could attempt the test again. So they never really, I guess they didn't really review, make any kind of determination about the right or wrongness of how they determined the time limits for the test. It is somewhat arbitrary. I know in the departments where I've worked, it's been pretty arbitrary as far as the different time. But again, sometimes I think the court skirts the issue of discrimination. And that's sort of maybe what they did here is they said that apparently they were, like I say, they were put back on the list. They would be restored to the place they would have occupied if they pass a new physical agility test approved by the district court. So they basically sent the case back. So this one involved physical agility. And I know that in many situations, that's where the IFC has come up with standard CPAT, I think it's called. And it is you don't have to do it that way, but it's recommended, it's valid, it's reliable, and it helps that you. Oh, that was Mike. That's okay. You have to go. Are you trying to mute? Okay, he's muted. All right, so, all right, Quentin, tell us about your case. Did you read the right case? Nobody else did, but that's okay.
Well, for my case, I have done research on the United Paramedics of Los Angeles versus the City of Los Angeles. During that case, the UPLA filed a suit against the city for the weight program as unconstitutional. But let's just face it, many people are really sensitive about their weight, and that's how they thought about this program. Mm-hmm. During this case, the UPLA argued that this weight program that did not take regard for their right of privacy, and that their weight was like their private medical information. Mr. Varone was stated that medical examinations and requirements must be based on the actual demands of the job, as well as the associated environmental hazards. Um, they have made really good points, but in the end, the judgment was affirmed, and they lost the case.
The paramedics lost the case?
Yeah.
My God, this.
Let's see. Okay. So did they say that weight was or was not confidential information?
Well, didn't really see that there, but again, many people are sensitive about their weight. Many people do not want to be judged by their looks or appearances, and they just really want the job.
And this actually involved an EMS department as opposed to a fire department or firefighters. And what the court did say is that that the fire department's concern for health and safety sufficiently justifies the weight management program. And I think that is something that we see. And if you relate this back to the Evans case that involved the physical agility testing, when I came in the fire service, and Mike, I don't know, you haven't been around that long. When I came in, we had to, in order to get your firefighter certification, you had to like run 1.5 miles, do so many pull-ups, sit-ups, push-ups, that kind of thing.
Yeah.
And they finally said, not job related.
Yeah.
And so that's when the physical agility testing changed to more job related. But it's still I know people that were overweight that could do that physical agility testing. They couldn't do anything the rest of the day, but they could pass their physical agility test.
Well,
so go ahead.
the one when I started, and when did you start?
19.
I was 90.
That's when I started. I was in 90.
The one we had to do then was the 1.5 miles, 13 minutes. I think there was a balance beam, and what they do now is an absolute joke at the state level. It is
really. You
don't even have to. It's ridiculous, and so of course I think every department has their ability to exceed that if they want.
Yeah.
And that's why I do. I like CPAT. I think it's across the board. It's a little expensive to get into it initially, to buy the equipment and the stair climber and everything, but I think it's just been proven and it's a good standard. And
that initial input of cash or money may be big, but it's nothing compared to what you might expend in a lawsuit or a complaint type of discrimination process that you might go there. So.
Right.
We have weight issues or physical issues. We have physical agility testing. We have promotional testing. And we have, Matt, I don't know what you would call yours. You can't hit your employee type of discrimination.
I don't think the issue was even so much the conflict between the employee. It was the discipline that came from the department that was the issue.
Okay, certainly.
And speaking of discipline, in that case, it was stated that the due process requires the LA Fire Department to individually test out the employee's fitness before submitting them to a punishable weight program.
Okay. So that's important as well.
Along those lines, our sheriff's office actually has an appearance board where every deputy has to go in front of this board in full uniform, and they, by judgment of a group of people, they're deemed whether they meet the appearance standard or not. And it's a weight, and it's never been challenged. If this board determines they don't meet it, they're given a program, X number of pounds to lose by a certain period of time, and based off percentages. And they've been doing that 5 or 6 years, and it's never been challenged, never had a problem with it. But it's based off of opinion. It's not based off any physical course or anything. It's a board of 5 guys. Look at this guy. Say, yeah, he looks good in uniform, or he doesn't. He needs to lose a few pounds.
Are the people on board employees, other deputies?
The command staff.
Okay. So that the command staff, do they police themselves?
They do.
How about how they
Very
look?
much so. Actually, yes, very much so.
Well, I kind of wonder.
They also, which they're very much about appearance. They're if you have any visible tattoos, year-round, long sleeves and tie, you can't have any. I mean, they're very strict on their appearance.
Mm-hmm. Interesting. Matt, you were going to say something?
I was going to say, I wonder if that's just one of those things that like a program the employer puts into place and it only flies because nobody's ever pushed the issue. Because that sounds like just a super easy way to, all of a sudden start, there's no check for you to, not abuse it for, racial discrimination purposes or discrimination against females in the sheriff's office. That kind of seems like one of those things that it gets by just because nobody's ever challenged it before.
Well, what I've noticed just with sheriff's office versus police departments is the sheriff normally being an elected official.
Yeah.
You work at his will.
That's right.
And
That's what I was gonna say.
Brings up a
That's
whole different set of circumstances.
Yeah, they can do whatever. They can fire you for any reason because you're hired by the sheriff.
Right.
But didn't the course already mention if you're working for a government agency, you've got a legal interest in your job that a private citizen working in the private industry doesn't have, so you're entitled to due process when it comes time to, if they're trying to eliminate you?
Sheriff's department is different.
I'm not sure they're a true governmental agency. I mean, they are in a sense, but you do serve at the, for example, right now, I was reading this morning, I don't know if y'all been, I was hoping Billy would be on here so we could get some scoop. Henry County Fire Department, they let their fire chief go. She'd been there a year or two, a couple of years maybe, doing a great job. 95% of the staff loved her. The citizens loved her, and the county commission said, you serve at our will, so see you bye.
Yep.
And they didn't really give her any reason. It's that same kind of thing, I think, with the sheriff, is that you serve at the will, and even though she probably has a legal interest in this Henry County situation, has a legal interest in her job, she still was serving at the will of, at the commission, and it can happen at any time. So I think is there room for a lawsuit? Sure. I think to test that question that you have, this board says, I don't look good in my uniform, so they fired me. Who are they to say that I can't do my job? And so there may be some, that may be one of those things that's a valid legal issue to raise. But, and many times it's like you say, that because nobody's ever pushed it, then it's okay. Everybody kind of accepts it as the status quo.
What's going to be interesting in that case you're just talking about is, I don't know how other county governments run, but in Columbia County, the division director and their assistant or number 2 person are under contract. And depending how strong that contract is, well, you met Chief Wall and Chief Pascal, they're both on 2-year contracts. So
Yeah.
I wonder if she was on one, and what if there's what kind of buyout package is in it. And I mean, that could get interesting.
Yes, it could get very interesting.
It sounds like there's no grounds at all to have let her go.
I've heard, just scuttlebutt about problems between her and another one of the administrators.
Right.
But it's total rumor. But yeah, just no grounds. There was, and even what I was reading this morning, there was a new article that had been posted where even the commission was saying, we want more information. We want to know why. We don't like it either. So it's going to be interesting to kind of see where that goes. But it sort of happened to my chief in Hall County. He was, they said, see ya, bye. They actually put him into EMA, but it was, we're good. Thank you. So it does get kind of iffy when you serve at the will of the employer. So, all right. Anything else? Okay, it's like 2012. I'm just going to look and see. Let's see. There's another case, Jerry O. Smith. This is Jerry. Jerry O. Smith in the city of Des Moines, Iowa. He sued the city for age discrimination. That would be me.
Me too.
He went through a long process of proving his health to be able to serve on the fire department with Des Moines. He went through about 6 years of back and forth doctor appointments to prove his ability to work and to wear the protective gear. They did not note any major health reason that would cause him to be unable to complete his task. He did fail the, you might have to help me out here, somebody, spirometry test and the VO2 test multiple times.
Lung capacity.
Spirometry, yeah.
Oh, thank you. Never heard of it. I probably know what it is, just can't pronounce it.
It's the thing where you have to blow into that tube and keep that little ball floating.
Yes, that. Okay, yeah. Heidi says it's a breathalyzer, but no.
Yeah.
It might be. I don't know. I do remember that. I just don't know that's what it was called. Let's see. So his own chain of command chose to put him in a medical retirement packet. He was placed on medical leave twice. They still chose to move him out to a retirement date and deny him his retirement pay. The EEOC found that he had a right to sue, but it does not tell me in this paper what his, here we go. I think that's not, here's Jerry Smith. A fire department may impose reasonable medical requirements upon firefighters that adversely impact members on the basis of age, where such requirements are a business necessity. There are two aspects of the business necessity defense: that requirements have a manifest relationship to the position. The requirements are necessary for safe and effective job performance. So, so they actually did not agree with Mr. Smith, and they boiled it down. It was not really age, but it was medical in his situation. So they kind of skirted the whole age thing, but obviously some of his issues were caused by age. I remember before I left Hall County, there were some of the of the male firefighters were talking about how they hoped that they wanted to make our physical agility test graded based upon age, where the older you got, the longer you had, you know. It didn't work that way. And so so age was not really an issue. It was more of that medical condition. So, and those are the only ones that I have information on. So it does cover kind of a wide range, as I said, you know, age, weight, physical agility testing, promotional testing, all of these things. I hope that as we go on, we see fewer and fewer cases based on discrimination. Of course, I think we see more hostile work environment and sexual discrimination, harassment now than we used to. And I don't know, I think it's because more females are coming forward and letting their voice be heard. But you know, that in no offense to anybody, but the fire service has historically been white males. Yeah. And it's just that job, and trying to work through some of those growing pains has led to a lot of these court cases. And I think we have come a long way in how we treat people. I was thinking the other day that if we just treated people nice, that we wouldn't need things like Title VII, Title IX for education. And, you know, if you just did the right thing and treated people right, then it might not be such a big deal. So any comments from you guys?
Welcome to the 21st century.
There you go, Quinn. There you go. I like that. I like that.
One thing I guess noticed over, and it's not so much, well, it's dealing with what this class deals with, but dealing with my bosses in the past is, depending where you're at is how so much of this stuff's interpreted. When it gets down to wage and hour laws and FLSA and who's exempt, who's not exempt, it depends almost what district you're in. You can take the same case in Georgia in front of a and they very much rule in favor of the employer. Where if you
Yes.
go in other parts of the country, they rule almost with the employee a lot. So the same case can go in front of 2 different courts and get 2 different answers.
That is very true. That is very true. It's, you know, it's like up north where the unions are very strong.
Correct. Mhm.
We're not that strong here in the South with our unions, and they will, they're recognized, especially, you know, in court cases. And I think that you are right in that regard. So it is, you know, we look at cases from other parts of the country, but we also have to figure out what works for us here.
That's right.
And,
Our district, or what, I can't remember what district it is, but they just have a tendency to deal with the employer.
Right, right, right. Anything else? Well, I'm so glad that we had this little get together. We have like 2 weeks left, or really, I guess a week of the true semester, and then the last week's finals week. So got to start wrapping things up, and I guess we'll see. I'll see some of you this summer. Good luck with the baby.
Thank you.
Keep us posted. Stay in touch. He's not having a baby, but his family, his wife, is having a baby. They are having a baby.
Hey Heidi, you got our paper done yet?
Yeah, but you're not supposed to.
La 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 la.
I was over here taking pictures.
You gotta watch her. You gotta watch her. So, well, all right, guys. I appreciate you taking time out of your day, and so we will see you next time. So, thanks
All
for
right.
joining us today.
Bye. That's all, folks.
See ya. That's all, folks. Bye, y'all. Thanks. I'm gonna try to post this recording. It's kind of scary, but I'm gonna post this so that I'm gonna see if I can post it on the course site if you want to go back and look at it. Yeah, no. But, that way, so that the others that weren't able to join us can watch it as well. They can see what fun they missed out on. All right, y'all take care. We'll see you.
Bye-bye.
Bye.
See you, Mike. See you, Matt. See you, Miss
See you,
Walker.
Queen.
Bye,
Yeah,
Quinn. Thanks.
What's your name again?
That's Heidi.
Bye, Heidi.